What we did to get ready for the habeas motion, and you were correct in pointing out that the Menendez case is on three different tracks. The first is a habeas motion where they're trying to get a new trial. This wouldn't get them out. It would only get them a new trial, but the standards are very high to get a new trial. In fact, the same exact arguments that Mr. Geragos has brought up have been rejected by the trial judge, the California Court of Appeals, the California Supreme Court on direct appeal, the California Supreme Court on habeas appeal, then the U.S. District Court and the Ninth Circuit Court of Appeals on habeas federal relief. So his arguments have been rejected literally every time they've been raised in 6 different courts. So what he's basically said is that he's got 2 new pieces of evidence, but those new pieces of evidence have to be subject to the rigid criteria of a habeas motion. They have to be timely, they have to be presented without substantial delay, they have to be admissible, and they have to be credible. And we went through each one of those factors to show that, for instance, the Eric Menendez to Andy Kano letter is supposedly sent in December of 1988. The problem with that, this undated photocopy of a letter, is that Eric Menendez testified for 7 days at his trial, a bit in graphic detail about the sexual abuse he experienced from his father. Andy Kano also testified in the first and the second trial. They said that the last time they had communicated about sexual abuse was 6 years before the 1989 murders in 1983. They were asked these questions many times, and they said the only time they had ever communicated was in 1983 when Andy Kano was 10 and Eric Menendez was 12 or 13. Voila, in 2023, we have a letter submitted, supposedly dated in 1988, that was never, ever mentioned during the trial. So that letter, we have great issues with its credibility. Again, because if it existed, it would have been used in the 1993 trial or certainly the 1995 trials. Certainly.
And it's a very cogent argument you make. You're much better at this than I am. But I want to play devil's advocate on that for just a moment. As a mom of boys, and I'm a mom of teenage boys who cannot remember what they had for breakfast. And I think about Andy Kano at 14 years old writing that letter. And I've read the letter, and it's about a lot of things. In the middle, there's the issue of, and it's Eric writing the letter to Andy. In the middle of it, there's the mention, very nebulously so, no words saying sex abuse, but it's happening again, Andy. And then the letter went into the, our pile of teenage things in our room, only to be found many, many years later by his parents after he died. Isn't it a fair argument to make that a 14-year-old would probably have no idea that there was a communication about sex abuse in a letter that was buried in the middle somewhere and never referenced as sex abuse, and that no one would ever know about it till it was discovered by those parents? Isn't it fair to say that is possible with a teenage boy who wouldn't even have remembered it even when on the stand?
It's not fair because the letter was written by Eric Menendez when he was 18. And remember, they were looking for evidence to show that the sexual abuse had existed for years, from the ages for him from 6 to 18. So the best evidence they could come up with corroborating it occurred in a conversation that happened several times 6 years before the 1989 murders. Now, I will assure you, if Eric Menendez had written that letter in December of 1988, 9 months before the murders, he would have used that to show that the sexual abuse was being discussed well before the murders, 9 months before the murders, not 6 years before the murders. But more importantly, the issue of both the letter between Menendez and Kano and the Roy Rosello declaration. Remember, that's a declaration where Roy Rosello says he was sexually abused by Jose Menendez in the early 1980s. The problem is the Menendez brothers never knew that until the 2020s. So it could not have played part of their state of mind during the August 1989 murders. But both pieces of evidence go to the sexual abuse defense, but it was not the legal defense at trial. What I pointed out is that Geragos has contradicted Leslie Abrahamson when she said categorically that sexual abuse does not justify the killing. She said it never did and it never will, and that they would never make that argument. Voila, 30 years later, apparently Geragos forgot to actually consult with with the prior counsel, who explained that sexual abuse is not the defense. It was always self-defense, the actual fear of imminent harm that their parents were going to kill them the night of August 20th, 1989. These two new pieces of evidence add nothing to the self-defense argument that they had. They are only additional information to the 7 days of testimony that Eric Menendez gave on sexual abuse, as well as the testimony that Andy Kano gave. So again, meet the rigorous standards to get a new trial of timely, admissible, credible evidence that would more likely than not change the outcome of the trial, these two pieces of evidence don't even come close.
I'm still on the credible only because, and I could probably have an hour-long conversation with you just on this letter. And you said Eric was what? Was he 19 when he wrote the letter to his cousin Andy? And I guess Andy was 14. I can see, was he 19? Was that it?
18.
18, okay. So I have an 18-year-old, and I can totally see how he would never remember that throwaway line in the middle of the letter. It's still happening, Andy, because the letter, again, was about everything. It wasn't about just sex abuse. It wasn't, hey, Andy, I got to write you something. This is happening. Help me. That wasn't the letter. The letter was, summer was great and things were happening. And by the way, it's still happening. And here's the rest of my letter. And I just look at teenage boys. They're morons. You know, I love them, but they're morons. And I just feel as though it is possible that Eric would never have remembered that line that he wrote in a letter when he was 18, and Andy probably never would remember it when he was 14. And that's all I ask. Isn't it possible that there's credibility to the letter, even if both of those boys got on the stand and never mentioned it?
No. And the reason it's not is that you gave us an example of a hypothetical 18-year-old and 14-year-old that are, going to, to the park, playing sports, going to schools. Eric Menendez is sitting behind bars. He's putting together his defense with his lawyers. They are searching for all evidence, and all they came up with is a conversations between Andy Kano and Eric Menendez. If they actually had something in writing, and certainly Eric would remember something he wrote 9 months, not 6 years.
That's where I differ. That's where I differ. DA, again,
Okay,
you're much better at this than I, but that is where I differ. Certainly he would remember that he wrote this tiny line in the middle of a very long letter about summer and fun and family. And again, we also have to put our heads on from 1990, right? And 88 and 85 and 84. We never spoke of these things. We never spoke at length. We certainly never wrote them in those words, sex abuse. It was just kind of a throwaway mention. It's still happening, Andy. I could see them forgetting that they'd written that.
So the letter comes to light, apparently, in 2015 during a Barbara Walters special on this case. But they waited 8 years till 2023 to actually present this letter in a habeas motion. And part of the habeas criteria says you cannot engage in substantial delay. The Supreme Court says anything more than 5 years is substantial delay. So even if you assume under your theory that somehow Eric Menendez forgot about the letter during his 1993 trial, forgot about it during his 1995 trial, didn't learn about it till 2015, he still does not meet the requirements of a habeas because he engaged in substantial delay of 8 years before he actually brought it forward. And this is years and years after Andy Kano had passed, so he's not around to cross-examine about the letter.
I have forgotten crushes that I had at 14, much more substantial than a few lines in a letter. That's all I say. I could, like I said, I could go on forever on this. I do want to ask you about resentencing because that's the next prong. And I feel like I'm getting an idea that you're not big on resentencing either. I think you've got some plans to go public with your strategy, your theory, your thoughts, and your I guess your plans, whether you're weighing or not. Can you tell me a little bit more about where your head is at with resentencing?
Certainly. So resentencing, different than the habeas motion, which the habeas motion only focuses on what happened at the trial. The resentencing motion is something somewhat unique for California and says that a judge can turn a sentence of life without the possibility of parole into life with the possibility of parole, and can consider a variety of factors beyond the trial. The judge can consider sort of looking at it as a before, during, and after situation. Before, what got the Menendezes in this situation to kill their parents? During, obviously, he's got to consider the facts of the case. After, he can consider rehabilitation that the Menendezes have engaged in since they have been in prison over the last 35 years. And even if the judge makes the decision to resentence to life with the possibility of parole, the next step is the parole board. And the parole board would then have to grant parole. And the final step is to go to Governor Newsom, because he has 120 days to either affirm the grant of parole or reverse it. And as an example of a situation recently where he reversed a grant of parole, I take you to the case of Sirhan Sirhan, the assassin of Robert F. Kennedy in Los Angeles in 1968. In that case, the parole board had denied parole 15 times in a row for 40 years. But on the 16th time in 2021, they granted Sirhan Sirhan parole when he was in his late 70s in diminishing health. And basically was at the point where he made the argument he was no longer a danger to public safety. But Governor Newsom reversed that grant of parole, saying that Sirhan Sirhan had not fully exhibited insight to his crime. He had not accepted full responsibility for what he had done wrong. Therefore, he constituted a danger, even though he basically was in diminished.
I have a minute left. I'm only jumping in because I only have a minute left. I hate interrupting, but I want to get your thoughts on this. It's so important. The Menendez brothers have taken responsibility for it. They have acknowledged they have done incredible things. I don't think Sirhan Sirhan did anything near what the boys have done. Can you tell me one way or the other? I love that you outlined the process because you're very good at this. But how you feel about it. Will you submit a brief? Will you have a microphone moment where you say, I'm not supporting this either, or will you support the resentencing? And how do you feel about Gavin Newsom either signing parole if they get it, or granting clemency? He could do two things.
So let me answer the last question first. Gavin Newsom can do the same analysis we did, review over 50,000 pages of trial transcripts, speak to defense attorneys, Menendez family members, prosecutors, law enforcement, do the hard work, and he could grant clemency and commute the sentence today or any day and release the Menendezes. He also, at the end of the process, can do that same work and decide if parole is recommended to grant or reverse parole. As far as we're concerned, within the next 2 weeks, we will be filing our position in connection with the resentencing. And what we're in the process of doing is not just going through the trial, as we've described in the habeas petition, but also going into the before and the after. What led the Menendezes to commit the crime and the rehabilitation they've engaged in since the crime in order to determine what the position should be.
But you're not going to tip your hat one way or the other tonight?
Again, I don't engage in hints, winks, suggestions. We're going to just rely on the facts and the law. And when we put our position out after that, I'm certainly happy to explain it in detail.
I'm guessing that will be before the March hearing, right?
Yes.
Okay. Can we make a booking now? Just tell me the date.
We will figure out a good booking to reappear on this show.
You can't blame a girl for trying. DA Nathan Hochman, I always love our conversations, and like I said, it could be an hour. Come on my podcast. We'll talk for a whole hour. Would that be all right?
We'll see if we can arrange that as well.
Okay. Thank you. Look forward to our next meeting.
Very good. Thank you very much.